Hello and welcome to Outside the Matchbox, episode 5. I am here today to discuss some important developments in both the seditious conspiracy case as well as the Mar-a-Lago search. So, I would like to first go over the Donald Trump's partial appeal to the Supreme Court of um, 11th Circuit's order that wouldn't allow Judge Deary to review the classified materials with the classified markings, approximately the 100 or so documents with classified markings. Uh, it's a because it is an appeal to the Supreme Court. It is drafted better than his other uh, documents have been, the ones that he has filed, but it's nonetheless uh, just nonsense. And the fact that it's riddled in contradictions, like so many other things that we see when we um, connect something to Donald Trump. It's all contradictions. It's lies and swindles. So what I'm going to do is give you point out to you the um, parts of the this particular interlocutory appeal. Interlocutory appeal in a civil case means it's an appeal that is part of an ongoing case on an important issue upon which the lower court has made a ruling that would cause the side against whom the lower court ruled irreparable harm. And there are many rules that surround interlocutory appeal. And what has happened in this case, I want to remind everybody the larger premise. The Department of Justice, pursuant to a lawful search warrant, conducted a search on Mar-a-Lago on August 8th and recovered thousands of documents that were not legally supposed to be there. Now, as they went into the investigation of this, this was an internal criminal investigation by the Department of Justice, which is an Article 2 branch department that investigates and enforces investigations by conducting prosecutions. They got a lawful search warrant from a judge magistrate of the third Article 3 branch of government to sign off on a lawful search warrant. That was Judge Bruce Reinhardt. We've even forgotten, it's in the back of our minds, this person's name. He is the judge who is rightfully supposed to oversee the criminal investigation over which he is the arbiter. He signed the warrant. He's overseeing the investigation. He issued the filter team protocols. And what we are seeing here today now, with Donald appealing a partial appeal of the special master order of the 11th Circuit, is an attenuation out of an aberration of the special master review motion to begin with, which Judge Cannon accepted the case on the basis of equitable jurisdiction, which is a really flimsy place to start. And consistently throughout this whole obstruction process of the special master case that Donald brought in Judge Cannon's court, it has categorically parsed and gone point by point and appealed and moved to a special master review. Then Judge Cannon has restricted and changed orders of Judge Deary, who is a special master, and extended the review and created this auspice that the Department of Justice, whose job it is under the Constitution to investigate, prosecute, enforce the laws of the Union, somehow has their words are not believable, and therefore the facts are in dispute, when they themselves state that we're not discussing the merits of the case. We're just discussing the procedures of how things are being reviewed and whether privileges apply. Well, if that's what you're doing to see if privileges apply, why are you saying that the facts are in dispute? Why are you saying that there's dispute on the matter of whether there is whether the classifications are legitimate or not? Because only the incumbent president and the enforcement branches of the incumbent president can assert what is classified, what is not. And for Judge Cannon to even grant a special master review, mind you, she wrote it down that she's inclined to a special master review. Excuse me for a moment. She's inclined to grant a special master review even before the DOJ replied to Donald's motion for a special master. So, but then again, in this motion for a partial appeal to the Supreme Court, Donald argues that the district court reviewed the briefs extensively before issuing the order. Well, she preemptively said that she would be inclined to grant the review before receiving the DOJ's reply. So if they are documenting themselves as having ruled prejudicially and then coming around and they're just flipping everything on their heads. So I'm going to read you portions of this, right? This is from Donald Trump's appeal to the Supreme Court, partial appeal of the 11th Circuit's order. And in this appeal, Donald Trump is asking the Supreme Court to take a partial review of the 11th Circuit's order granting the stay that DOJ wanted as to the 100 classified documents with the classified markings. Not the rest of them. Judge Deary has the rest of them. And I would infer that this is happening because DOJ filed a motion to expedite their appeal in the 11th Circuit of the entire special master review, thereby bringing the whole sham of this special master process into question. So, mind you, what the DOJ did with appealing the special master motion wasn't an interlocutory appeal. The asking for the partial stay was an emergency motion because that was causing irreparable harm to our national security. But the larger appeal of the special master review as a whole is still pending in the 11th Circuit, and Donald Trump has replied to the motion of expediting the appeal. While that's happening, here's another interlocutory procedure. So to go up to the Supreme Court to adjudicate whether Donald Trump, whether Judge Dearie should receive those 100 classified documents that the DOJ will not release to the 11th Circuit, to Judge Dearie, and the 11th Circuit agreed with the DOJ. So what Donald's appeal to the Supreme Court says here is the unprecedented circumstances presented by this case, an investigation of the 45th President of the United States by the administration of his political rival and successor. Well, at least he says successor, meaning he's now the incumbent president. Also, Donald Trump has not ever not included this political rival argument. But one thing, and one distinguishing reason why this is not a political issue, is that this search warrant, and they even question the verity of the search warrant, this search warrant was signed off by an Article 3 judge, by a magistrate. So, as procedure should happen for any private citizen of the United States who is not afforded any of the privileges other than attorney-client, spousal, clergy, and other any other privileges, medical privileges. Other than that, Donald Trump has no executive privilege at the moment. And that issue is also, mind you, he hasn't brought up any of the executive privilege issue. That's still stuck with the Dearie special master review. This unwarranted stay should be vacated as it impairs substantially the ongoing time-sensitive work of the special master. I wanted to read this to you because I wanted to show you here what I mean by flipping everything on its head. The time-sensitive work that is being delayed is the DOJ's criminal investigation that was intervened by the special master motion by Donald Trump, which put a stop to the DOJ's investigation and which brought the investigation to a halt that caused the appeal to the 11th Circuit. And you see how he has flipped it on its head in this argument here? This application seeks to vacate only the portion of the 11th Circuit stay order, limiting the scope of the special master review of the documents bearing classification markings, as I said to you. So, then, in furtherance with his request to be protected from the consequences of an unlawful search and seizure of his property, I wanted to read this little part snippet to you because he's asserting in a motion to the Supreme Court that a lawfully executed search warrant based on a lawfully issued search warrant by a magistrate is an unlawful search and seizure of Donald Trump's property when the DOJ, which is the enforcement branch with the authority to assess whether something is classified or not, has said repeatedly and has gone to untold lengths in describing to the courts and to the American people how this is a national security matter. But still, in this appeal, Donald says this is an unlawful search on his property. Then it goes on to say the district court exercised its equitable jurisdiction and inherent supervisory authority to safeguard the rights of President Trump as a citizen, subject to potentially unlawful search and seizure, and granted President Trump's motion in part. As I said earlier, the equitable jurisdiction thing is flimsy at best because equity would favor the party that has presented most evidence, facts, as to why the documents should not be given to Donald Trump or the special master review should not be conducted, because they have interjected and overreached into core executive branch functions. Inherent supervisory authority, I don't recall Judge Cannon being the supervisory judge of Judge Reinhardt. If that is the case, then there is supervisory authority. But over any abuse of discretion or misapplication of the law by the judge magistrate, and there has been no showing that Judge Reinhardt did anything wrong, and Donald hasn't brought that up either. So the next part, indeed, in what is essentially a document storage dispute governed by the Presidential Records Act, the government has sought to criminalize President Trump's possession and management of his own personal and presidential records. So this is just an assertion that they are saying, Donald Trump is saying that these are mine. But throughout the process of the special master and Judge Dearie asking them to prove that this is theirs, that he in fact did declassify them, or that they fall under any of his private property, what they are, he doesn't want to say that. And he, in fact, Judge Cannon went and stopped Judge Dearie, which caused the DOJ to appeal to the 11th Circuit. Do you see the circuitousness of all of this, the hamstringing that's going on here? Nobody's seeking to criminalize anything because the DOJ hasn't filed a criminal indictment. The investigation is ongoing. So where is the government has sought to criminalize Donald Trump's possessions come from? It is still in the investigative process. Then they go back to quoting the district court, Judge Cannon's order. I'm going to read these excerpts and parse through them. Taking into account the undeniably unprecedented nature of the search of a former president's residence, well, no other former president has taken what the DOJ surmises to be classified documents. Plaintiff's inability to examine the seized materials in formulating his arguments to date. Plaintiff had those documents for 19 months. So if they didn't examine those documents in that time, what is to say that it's going to take another 19 months for them to assess the documents if they receive it now? Which is one of the arguments that the DOJ points out in the potential of indefinite delays. Plaintiff stated reliance on the customary cooperation between former and incumbent administrations regarding the ownership and exchange of documents. Well, that's what those 11 months of communicating with NARA and the DOJ did not yield. And that's why this is where we are. So, and by the way, the DOJ has shown that over and over again. And in fact, Donald even talked about how those events occurred. So those facts are not in dispute. Yet, here we are with Cannon's order. The power imbalance between the parties. Well, the private citizen and the state. That is a perpetual power imbalance that is part of any criminal investigation into any private citizen, which happens every day all over the United States. The importance of maintaining institutional trust, which Judge Cannon breaks down on and attacks by saying that the DOJ's assertions as to their criminal investigations into classified documents belonging to the government is somehow in dispute. So who is maintaining institutional trust here and who is breaking it? And the interest in ensuring the integrity of an orderly process amid swirling allegations of bias and media leaks. Mind you, that nobody would have known about this search had Donald not publicized it. So that's where this started. That's where the gates were open. And when you open those gates, when the DOJ walks through them subsequently, that is still on Donald. None of this would be happening if Donald didn't publicize the search and then go on to intervene and impede a governmental investigation with national security implications. Then the district court says the parties' submission suggests the existence of genuine disputes as to whether certain seized documents constitute personal or presidential records and whether certain seized personal effects have evidentiary value. Because of those disputes are bound up with plaintiff's rules 41G request and involve issues of fact, the court must receive evidence from the parties thereon. That step calls for a comprehensive review of seized property. But then again, even in this appeal, they say that no, we're not addressing the merits of the case. So this is not a fact-finding process we're engaged in. This is all procedural. However, here the district court is sowing genuine dispute into the factual record. So you have to ask, which is it? And I hope the Supreme Court, if it takes the appeal, will ask that. I would hope that the Supreme Court would just throw away and not grant certiorari. But this is a desecration of the federal bench. This is the desecration of federal courts. This has been happening now for 2 months. So if the Supreme Court does intervene, they need to question whether what Judge Cannon has done is proper before addressing any of the other questions. And that should be enough to stop them from even going further and giving the case back to the DOJ to investigate. Then the appeal goes on to say the government's position thus, this is still part of the appeal quoting the district court. The government's position thus presupposes the content designation and associated interest in materials under its control. Yet, as parties' competing filings reveal, there are disputes as to the proper designation of the seized materials and legal implications flowing from those designations, and the intersecting bodies of law permeating those designations. Now, again, there are disputes as to the proper designation? No, because it is the enforcement branch, it is this Article 2 branch of government, the presidency, and thereby the DOJ, by way of the presidency, that assigns the designation. That designation, the Article 3 branch of government doesn't have the authority to dispute or bring that designation into question unless that question is being brought in a court of law as part of a case brought to the court. And that factual case has not been brought to the court yet, as repeated many times over. Now, here, the Donald's appeal says the PRA contains no provision obligating or even permitting the archivist to assume control over records that the president categorized and filed separately as personal records. At the conclusion of the president's term, the archivist only assumes responsibility of the presidential records. Well, thank you for saying that, because that process, the process, since process is so important to Donald, that process of the archivist assuming responsibility of presidential records didn't happen because you thought you could bypass it and take those preemptively. So thank you for at least, conceding that the archivist assumes responsibility of the presidential records. The PRA does not confer any mandatory or discretionary authority on the archivist to classify the records. Under the statute, this responsibility is left solely to the president. Mind you, the current president. So even if Donald had executive privilege or the authority to take those documents to Mar-a-Lago when he was president up until noon of January 2021, from that day onwards, when President Biden and Vice President Harris took office, he no longer had that right. It was his requirement under law, under the Presidential Records Act, as he concedes, to return those documents to the National Archives and then request for them back. There's jargon about President Bush and President Obama. I don't know the verity of the facts of what happened, but I would bet my bottom dollar that both President George W. Bush and President Obama followed the process of letting the archives assume control and responsibility of the documents before going back to them and asking for them. Critically important here, again, reading the appeal, President Trump has sole discretion to classify, had the sole discretion to classify a record as personal or presidential. Of course, sure, he did, but neither is he president at the moment, nor did he show to Judge Cannon, Judge Reinhardt, or Judge Deary. When Deary asked, Judge Cannon said, no, you don't have to show that, as to whether he did declassify those documents or not. So, absent showing of fact that those documents were declassified by the president per procedure, not just because he took them at the time he was president. Well, if that is the argument, that he took them at the time as he was president, the minute he stopped being president, what he did stopped being legal, and it was his job to return them. The fact that he didn't constitutes the violations. So I suppose this appeal also has some concessions without realizing it. Congress provided certain parameters for controlling classified information, but primarily delegated to the president how to regulate classified information. Again, thank you for conceding that. President of the United States currently is Joe Biden, which in this appeal, Donald himself concedes by saying that he is the 45th president and this administration is of his successor. So that primary duty is of Joe Biden's, not Donald Trump's. So if Donald Trump's argument flies with the Supreme Court that he took it when he was president and therefore he declassified them and therefore they're his, the moment he left and stopped being president, it automatically became Joe Biden's, because it is government property, and the government has shown that it is government property through letters from the investigative director of the FBI and countless other ways in their replies and motions in this special master review. So then here we go. Here it simply cannot be an abuse of discretion for the district court to refer these matters to a special master to determine whether documents bearing classification markings are in fact classified, regardless of classification, whether those documents, and regardless of classification, whether those documents, whether those records are personal records or presidential records, such that their disposition may be managed properly under the PRA. Who is the special master to designate documents classified? That is not the job of a special master pursuant to an order by a civil court judge who intervened in a DOJ criminal investigation pursuant to a lawful search warrant that a judge magistrate signed. Where does the district court have the right or the authority to question the verity of that designation, absent any showing from Donald's part that he did anything to declassify those documents or any other process to comply with the Presidential Records Act. In fact, this government, the DOJ, has provided ample proof that Donald has not complied with these requests, these statutes that he has repeatedly violated. And they have been compelled to make these disclosures in court because Donald brought this case. Then finally, the final excerpt that I want to focus on, as correctly stated by the district court, President Trump faces an unquantifiable potential harm by way of improper disclosure of sensitive information to the public. Now, there are so many things wrong about that statement. President Trump faces an unquantifiable potential harm. As I have said many, many times before, it is an untold law in jurisprudence that when you speak of a harm that is being caused to you because of a certain conduct, you have to specify that harm. And that harm had to have happened for you to bring a cause of action to court. So here, this idea that faces an unquantifiable potential harm is just buffoonery. And then you add to that, by way of improper disclosure of sensitive information to the public, 11,000 government documents, including 100 documents with highly classified markings, were stored in Mar-a-Lago in Donald Trump's desk. That is a flagrant violation of any documents with that level of classification that the DOJ has said repeatedly. So much so that the DOJ is going to great lengths to both appease Donald's tantrums and continue the investigation and go to the appellate court with just request of keeping these 100 classified documents, because these 100 extremely classified documents were improperly stored for the last 18 months at Mar-a-Lago, which is a country club. And Donald Trump is facing unquantifiable potential harm from improper disclosure of sensitive information to the public? No, it's a government that has already incurred irreparable harm from the delay of this investigation for the last 2 months and the continued delay of it by these sub-interlocutory appeals by Donald, these interjecting, overreaching acts that has been perpetuated by Judge Cannon's special master motion. That has been further perpetuated by Judge Cannon micromanaging the special master motion and telling Judge Deary what he can and cannot ask for in his review. And then going up to the Supreme Court while the appeal is pending in the 11th Circuit of the entire review to say that, no, you have to tell the 11th Circuit to return, to give back, compel the DOJ to give back those 100 highly classified documents to Judge Deary and thereby the plaintiff's counsel. That would not cause any irreparable harm is what Donald Trump is asserting here. That a DOJ criminal investigation with national security implications, with assertions that the 11th Circuit has agreed with, has caused and is causing and will cause irreparable harm to our government and our national security, is somehow a less of an interest of the government and of the courts than Donald Trump's unquantifiable potential harm of improper disclosure of sensitive information to the public. The absurdity of that claim is redundant in that statement. So now the DOJ will reply. Let's see what they have to say. Then it'll go up to the Supreme Court. I would hope the Supreme Court would issue an order similar to the one with Trump v. Thompson, and deny the grant of cert, and maybe the ruling will be 8-1 or 7-2 because Kavanaugh and Thomas are, compromised. So that's where we are with that. The second thing I wanted to discuss with you are developments from the seditious conspiracy trial that is ongoing. And these are reportings that have come up just today. Now, I discussed with you in the previous segment about why the Insurrection Act argument wouldn't work. And I explained to you what we have the government asserting in the case here. The government interprets, this is from Politico. Government interprets it as authorizing, meaning the Insurrection Act. Government interprets the Insurrection Act as authorizing the president to call up National Guard forces to suppress domestic unrest. Rhodes' attorney says it empowered Trump to call up less formal bodies like the Oath Keepers. So that is the assertion here, is interpretation of the Insurrection Act, whether that would have given the Oath Keepers any legitimacy. But as I've explained before, that is part of many of the other non-arguments, because either you are there for free speech and bravado, or you are there for Donald Trump's invoking of the Insurrection Act. And I talked about this a long time ago, before the insurrection, that don't go there, don't be a part of any sort of conflict with them. And I'm so happy that none of the non-MAGA protesters were there on January 6th, because that's what they were banking on. That's what you can see from their communications as the case unfolds, that they were actually banking on Antifa being there. You see what I mean? And that didn't happen. And if you go to my warning that I gave to Lincoln Project, that's on my channel, from Veterans Day, November 2020, I said that they would cause that and invoke the Insurrection Act. And that was their plan. I was warning as they were planning this. Now, these are portions of Rhodes' text message. The final defense is us and our rifles. Trump has a duty to stand, but so far he hasn't, as Roger Stone said. Of course, Roger Stone comes up again. As I've said many, many times, every single one of these aspects of the seditious conspiracy has Roger Stone's fingers all over it. Then we learn that Rhodes is accused of encouraging and carrying of a hard helmet with the use to strike someone with, and there's discussion of attaching flags to lead pipes, right? I mean, free speech and bravado doesn't match with this. This group is accused of knowing DC gun restrictions, and of staging guns outside the city limits of January 6th. So that goes to the overt planning of being part of a militia that was planning to attack the Article 1 branch of our government. The FBI agent testified that Stuart Rhodes is heard referencing plan of everybody to be armed outside of DC if the president calls us in. You see, I mean, the president calls us in. We're going to learn a lot more about that, because we're going to learn how did they get to that they knew it was the plan for Donald to invoke the Insurrection Act. What was the plan? We're going to learn about the plan. Here's Mr. Rhodes saying, so our mission's going to be to go into DC, but do want some oath keepers to stay on the outside and to stay fully armed and prepared to go in armed if they have to. So if the shit kicks off, then you rock and roll, okay? All right. Yeah, that's very free speech and bravado. But we also want to have some of our best men posted up outside. We'll have to make a determination of who goes where and who's going to be on the outside and who's going to be on the inside. So we're going to have a quick reaction force, armed QRF, armed quick reaction force, but the quick reaction force will be awaiting the president's orders, okay? That's our official position. And the reason why we have to do it that way is because that gives you legal cover. So, I mean, self-explanatory. But let's make no illusion about what's going on in this country. We're very much in exactly the same spot that the founding fathers were in March 1775. Now, and Patrick Henry was right, nothing left but to fight. And that's true for us too. We're not getting out of this without a fight. There's going to be a fight. But let's do this. Let's do it smart, and let's do it while President Trump is still commander in chief, and let's try to get him to do his duty, and step up and do it. A lot of do-its and fights, and going back to 1775. Then he said, if the fight comes, let the fight come. If Antifa if they go kinetic on us, then we'll go kinetic back on them. I'm willing to sacrifice myself for that. Let the fight start there, okay? That would give President Trump what he needs, frankly. Thank you for being frank, Elmer. If things go kinetic, good. If they blow bombs up and shoot us, great. Because that brings the president his reason and rationale for dropping the Insurrection Act. Do you see what I mean? Do you see what a great duty you did if you are Antifa, anti-fascist? I am anti-fascist. If you are Antifa like I am, and you decided not to go and be there physically and have physical altercations with these people, because that was part of their plan. That was an operative part of their plan. And when that failed, their whole house of cards fell apart, as does his argument here. So when you have these texts, these meetings coming out, no one is disputing that these meetings and these texts are true. They may be claiming, no, these are improperly gotten and da. They're not saying they're not true, mind you. So that's where we are. We're getting closer and closer to understanding the planning that went behind and the rationale that these militias were using. And it's as transparent as day, and it's like me reviewing my warnings from November of 2020. You know, go back to my live streams. They're timestamped, and this is what I talk about. The third thing that I want to talk to you about is the GOP continuing to minimize what happened. Senator Ron Johnson, speaking to the Milwaukee Rotary Club, said about January 6th, some of the protesters did teach us all how you can use flagpoles, that kind of stuff as weapons. But to call what happened on January 6th an armed insurrection, I just think is not accurate. And he was talking about that as right now we are in a seditious conspiracy, in the middle of a federal seditious conspiracy trial with evidence of them having guns and pepper spray and grenades and batons, which are not, I mean, you see how Senator Ron Johnson is just lying. And the fact that they are still doing that as these trials are happening in a court of law based on evidence and trial process gives you an idea of how much of a problem this has become. This is subversion. To say that January 6th was not an armed insurrection is subversion at this point. It has been proven, it has been shown in so many ways that if he's going to uh, take this case to the court of public opinion and make that blatant lie, he needs to be called out for that. The fourth topic that I want to discuss with you, and this is the last topic, is that there's the ninth January 6th committee hearing will be tentatively on October 13th, and we are likely to hear things about Secret Service, about Ginny Thomas, about John Eastman, and currently John Eastman and the Select Committee are in a tiff about some more of his emails and messages. So, you know, that's where we are with these topics. I wanted to come out and discuss them because I wanted to inform you from what I saw. So let's see how it goes this coming week. Tomorrow should be interesting. It's going to be a couple of years of heavy weeks coming up. I want everybody to know. And slowly more and more eyes will open. And I refuse to be stamped out of informing my fellow Americans. And when there's a will, there's a way. And I will keep up with the news and I will come out here and inform whoever will listen about the facts as I see them. And if you like what you see, if you like what you hear, please share, subscribe, and like. I appreciate every single one of you. And here, so now I'm going to go to the comments. It seems like they are going. Yeah, they are. Well, I mean, I wouldn't say 2023, 2024. Well, I mean, if you're talking about, I'm talking here to the question of Neza, Neza Hall. Yes, you. Um, um, these are the indictments from the special master and the January 6th insurrection are they're independent. They're not fact related. They're not related to one another. So um, whether it'll be the 2023 and 2024, I don't know. With the special master, but I could say that the January 6th one could come sooner. Um, the special master, I mean, the DOJ Mar-a-Lago search and any criminal indictments coming from them will be easier to prove in a court of law simply because those statutes are pretty cut and dry. But the January 6th, the evidence is overwhelming, albeit circumstantial, because we're never going to get Donald to tell us the truth about anything. So let's hope to see, and I hope to see an indictment at the end of this year, and if not, by spring of next year, 2023. So with that, I'd like to say thank you for anybody who's been here. Thank you for the likes. I appreciate you all. And take care.